I'm John Rafferty, the president of the Secular Humanist Society of New York. And this is the continuation of our celebration of Free Thought Month. Very quickly, Free Thought Day and Free Thought Month is all about the accomplishment in 1692 of Governor William Phipps of Massachusetts, who ended the Salem witch trials by declaring that spectral evidence meaning, I see the devil in the corner, no longer admissible in the courts, and only what could be seen would be obvious to the senses, in other words, reason, would be accepted in the courts of the colony of Massachusetts. So Governor William Phipps, Free Thought Day, Free Thought Month, feel free to think freely all month long. At any rate, in addition to other duties, I handle as for my sins, as the Catholics say, I handle the membership of the organization. And each year, I would send out, each month, I should say, of the year, I would send out the letters saying, it's time to renew. And for several years running, this name Norman Dorsen would pop up. And I'd say, I know that name from someplace. And I meant to look it up, but of course then I'd be, printing out the labels and doing all that nonsense, and I'd forget. And the next year, come around and do it again. Finally, a little over a year ago, I just stopped. And I went, and I Googled Norman Dorsen. And my reaction was, wow. Longtime member of the Secular Humanist Society of New York. Norman Dorsen is Stokes Professor of Law at NYU School of Law, where he has taught and directed the Arthur Garfield Hayes Civil Liberties Program since 1961. He was the founding director of NYU's Hauser Global Law School program in 1994, and starting in 2001, he has been counselor to the president of the university. Norman was in the Army at the same time as I was, in the early 50s, and where I watched the Army McCarthy hearings on the television set in the day room of the company, the Army base where I was stationed. Norman was advising the Army's lawyers in the Army McCarthy hearings in 1954. After that, he served as law clerk to Chief Justice Calvin Magruder of the U.S. Court of Appeals for the First Circuit and to Supreme Court Justice John Marshall Harlan. He is the author of editor of many articles and 15 books on constitutional law and human rights. He was the founder and through 2008 was editorial director of the International Journal of Constitutional Law. He served as president of the American Civil Liberties Union from 1976 to 1991. Earlier, when general counsel of the ACLU, he argued many Supreme Court cases, including those that won for juveniles the right to due process, upheld constitutional rights of out of wedlock children, and advanced abortion rights. He also helped write petitioner's brief in Roe v. Wade and appeared amicus curiae in the Gideon case, the Pentagon Papers, and the Nixon Tapes case, among others. Do you wonder why I said wow? Norman was the founding president of the Society of American Law Teachers and was a principal organizer of the International Association of Law Schools. He was chair for 4 years of the Lawyers Committee for Human Rights First, and he chaired citizens commissions for the U.S. Department of Health, Education, and Welfare and for the U.S. Treasury Department. The French Minister of Justice awarded him a medal for his civil liberties work. In 2000, President Bill Clinton honored Norman with the Eleanor Roosevelt Medal for contributions to human rights, and in 2007, the Association of American Law Schools presented him with its first Triennial Award for lifetime contributions to the law and to legal education. And tonight, we are honored to have Norman Dorsen as our guest and our speaker. Please welcome Norman Dorsen.
I thank you very much for extending my biography. I appreciate it. And actually, I've made one important change in my remarks, and that is that instead of 6 crises, I'm going to mention 7 crises. Things move quickly. And in a sense, every action that the ACLU takes is a crisis, because every one of them raises, one way or another, a civil liberties principle that the organization tries to protect or advance against the government or some other powerful entity. And it has taken several books to fill in all the details. I'm going to try to be as concise as possible. So the first crisis was the founding of the ACLU in January 1920. Before the ACLU, there were a few special issue organizations in the United States, the Free Speech League, the Legal Aid Society, for example. And there were also organizations such as the NAACP and the American Jewish Committee that were founded to protect the rights of a particular group in society. So how did the ACLU happen? The roots were in World War I, which was not a particularly popular war among many people in the US, unlike the Second World War, which no one loved, but most people felt it was a necessary conflict. And an organization was formed called the National Union Against Militarism. And they went out and they circulated documents, they made speeches, they tried to convince people to join and to oppose the war, and the government came down very hard on them. So they felt they needed somebody to protect their right to speak. And what they did was organize a Civil Liberties Bureau. And the Civil Liberties Bureau did what you'd expect, mainly protect the right of the organization that hired it. The person they chose initially to be the head of the organization was a woman named Crystal Eastman, who was a graduate of NYU Law School, as a matter of fact, and a very prominent and outstanding person. But she got ill, so they couldn't put her in the job, and they went to St. Louis, and they hired a man named Roger Baldwin, an Easterner, what I would call a lower upper class person, went to Harvard, and became a social worker, which was not the usual thing for graduates from Harvard at that time. In any event, he came back to New York and headed the Bureau. This, incidentally, was, to the best of my knowledge, the first use of the term civil liberties in the US, and it was taken from the British National Council on Civil Liberties, which I'll say a word about later. Now, there were 2 key issues at the beginning. One was the protection of rights across the board. This was not a free speech organization. It was not an organization to protect the rights of people accused of crime. It was not an organization designed to protect racial minorities or other groups from discrimination. It was all of those things. And no other organization had that goal. But the second, and in some ways even more important fact, was the importance of even-handedness in applying the principles of the organization. So here's the only quote I'm going to read in this talk. It's what Roger Baldwin, the founder, this is what he said at one point. The tests of the loyalty of the ACLU to its principles lies in the impartiality with which they are applied and the character of its leadership. No favorites in defense of rights for all, no contradictory loyalties in the minds of the leaders. Excuse me. These are hard tests to impose against natural sympathies and prejudices, harder perhaps to determine the consistency of anyone's loyalties and beliefs, even harder to defend the thought that we hate. I would not claim that the ACLU has always met that test. Indeed, I'm sure it hasn't. But I would say that the organization tries to get it right, often in very difficult circumstances. It's important to recognize that civil liberties does not include many liberal ideas. For example, protection of the environment or economic issues such as the minimum wage. There are limits. In any event, in 1918, just before the end of World War I, Roger Baldwin was called up for military service. He was just below the age. He refused to submit, and he was jailed for a year. He lived very well. Some of you may have seen the Charlie Chaplin movie, Modern Times. Well, Baldwin could have been the model for that. He lived better in jail than he ever had lived before in his entire life. In any event, he and other people decided, though the war was over, that civil liberties needed to be protected. And he went upon organizing the ACLU. People call him the founder of the ACLU. He always rejected that word. He said, I was the principal organizer. He didn't like the word founder. Well, among the obvious questions were how to raise money, how to get members. The money was solved by a man aptly named Albert de Silver, who was a wealthy New Yorker with liberal views, and he virtually carried the whole organization for several years until he died prematurely in 1923 or 4. Membership came slowly. Dues were $1 a year. In the first annual report, every single member in the entire country was listed by name. There were about 1,200 or 1,300 members. The balance sheets showed at the end of 1920, the first year, that the ACLU had $800 in the bank. Now the organization has 500,000 members and an endowment of $200 or $300 million. I do not want to discourage anyone from joining. In any event, the organization was born. So the next question was crisis 2, getting established. After the founding, what should be done? How do you get established? What is a civil liberty anyway? They do not come down from Mount Sinai on a tablet. For the ACLU, a civil liberty is what its board of directors decides as a civil liberties. But where were they in 1920? The ACLU confronted a blank page and could only look to the text of the Constitution, the civil liberties issues of World War I, and their own instincts for guidance. The founders soon learned that civil liberties issues are not merely abstract ideas, but are thrown up by the messiness of life and must be dealt with in a pragmatic as well as a principled way. For example, one of the first issues were the hundreds of Americans who were jailed for sedition, that is, for opposing World War I. Many were in jail for years. Socialist candidate for president, Eugene Debs, campaigned from jail. It took years to clear all the prisoners. There were also strong anti-immigrant feeling, spurred by the reaction to the Russian Revolution in 1917 and the fear of domestic violence by those newly arrived in the US. The Attorney General named Palmer went to the homes of immigrants, took them out, put them in a bus, took them to a boat, and sent them home without a single trial or accusation in paper or having a lawyer. And this, the Palmer raids, as they were called, was of course a major issue. Now we're seeing another round of anti-immigration fervor at the moment, and it proves again one of the theorems of the ACLU, that no civil liberties issue ever stays won, that you have to fight for the right again and again and again. Another issue which led to bitterness and anger, arose from attempts by workers to organize unions. Much violence right through the 20s and the 30s until 1937, when the National Labor Relations Act was finally approved by the Supreme Court. And then censorship. These are the early issues, especially of pro-union, radical, and sexually laden speech. Sadly, the first annual report of the ACLU in 1920 did not mention women's rights, and in particular the 19th Amendment that granted women the right to vote, which was ratified in August of the ACLU's first year. I recently had occasion to look at the annual report for the first year, hoping that they would mention it, but they didn't. The case that put the ACLU on the map was the so-called monkey case of the mid-1920s, when a young teacher from Tennessee named Scopes taught a certain theory of evolution of Charles Darwin's fame that challenged the divine creation of man in defiance of a criminal law in Tennessee that banned such teaching. The case became a sensation, was made into a movie. The opposing lawyers were extraordinary in their prominence. William Jennings Bryan, who had been the Democratic candidate for president in 1896, represented the state of Tennessee, and Clarence Darrow, the most famous lawyer in the United States, assisted by Arthur Garfield Hayes of the ACLU, defended Scopes. Scopes lost, but there were headlines for weeks, and the case brought ACLU notoriety and money, as well as much greater understanding among the public of free speech principles. So now we're moving into the late 20s, early 30s. The ACLU was established. The next crisis was over communism, not McCarthyism. That came later. I'll say a word about that. But in the 1930s, the ACLU worked closely with communists and other far-left groups in what was known as the Popular Front. Liberals and leftists, Depression-era disillusion with an intolerant and to many an inequitable form of capitalism. And on the horizon was Hitler, whom the communists fiercely opposed, and therefore recruited members on that ground. This changed in 1938 when the House of Representatives established the Un-American Activities Committee. Although the committee acted a few times against fascist groups and individuals, its chief goal was to identify, expose, and destroy communism in the United States. The committee warned the ACLU that it would not tolerate communists on its board or staff, of which there were some. This was a big problem because the ACLU then was small, poor, and weak, and the public investigation might have ruined it. The problem came to a head, the heart of the third crisis, over Elizabeth Gurley Flynn, a founding ACLU board member in 1920, who was a well-known communist for many, many years. Being viewed as a good civil libertarian by her colleagues, she was reelected despite her affiliation. HUAC, the House Un-American Activities Committee, demanded that she be removed from the board. The internal conflict was fierce, and the board decided to hold a hearing at a New York hotel in 1940. The subject of a long and highly critical book, The Trial of Elizabeth Gurley Flynn by Corliss Lamont, shows that the final vote at about midnight was 8-7 in favor of her expulsion. There were plenty of postmortems concerning which board members did not attend, which came early and left before the vote, etc. After that, the board of directors passed what came to be known as the 1940 resolution, which barred Nazis, fascists, and communists from leadership roles in the ACLU, and put this information on a card given to all members. There were not many Nazis and fascists who wanted to be members of the ACLU. Now all this obviously was inconsistent with ACLU principles as they were enunciated then and now that membership alone in an organization should not be punished, that you need acts of some kind to implement your ideas, that acts that are unlawful. Now, the situation was complicated a great deal by the fact that Roger Baldwin, the leading figure in the ACLU by far, earlier in the 20s was sympathetic to the Soviet Union. And he wrote to that effect in his Harvard 25th anniversary yearbook in 1931. And even though Baldwin turned anti-communist strongly during the mid and late 30s, saying that was impossible to work with them, this fact remained. And during my presidency of the ACLU, which, as you heard, was 1976 to 91, and I would go around the country, make speeches, speak on talk radio, many, many times people would call in and say, why should we give a damn about the ACLU? You're a communist organization. Let me read to you what Roger Baldwin said in 1931. Now, this was all planted by people, but nevertheless, it was a fact that Roger was sympathetic, as many intellectuals were, not all by any means, with the Soviet Union, given some of the problems in the United States. Now, the ACLU Board of Directors in the 1970s, by that time I was on the board, voted to reinstate Flynn posthumously, but the debate continues. My NYU colleague, Professor Burt Newborn, who is a former legal director of the ACLU, recently revised his earlier criticism of the Flynn expulsion and said that the action was necessary to save the organization, that HUAC would have destroyed the ACLU if they didn't do that. We'll never know the answer to that, but it's still an open question. In the late 1940s, McCarthy arrived, and society was rent by government and private actions against suspected communists and communist-dominated unions and other organizations. Many non-communists, leftists, and liberals were caught up by these events and lost their jobs and other benefits. The ACLU entered many cases in opposition to the McCarthy attacks, but it refused to represent the Communist Party or its leaders directly because it did not want to have to argue in court that the Communist Party was not oriented to violence or other lawbreaking. Because if you're defending someone, you've got to make every argument that you can make. And the board of the ACLU at the time felt that was in the late 40s and early 50s, that it couldn't conscientiously say that the Communist Party was not doing some things that were illegal. In any event, it filed amicus friend of the court briefs with the courts. But there are many, even today, who say that the ACLU failed adequately to defend witch hunts and criminal charges against communists. Others say that the ACLU not only did much to oppose McCarthyism, but it did all it could. In 1950 and 51, after extensive internal conflict on this issue, among others, a group of ACLU leaders and others formed a new organization called the Emergency Civil Liberties Committee. It was headed by Corliss Lamont, who provided much of the funding. He was the son of a partner of J.P. Morgan. And Leonard Boudin was the top lawyer. His daughter Kathy has been in the news lately, as some of you know. Leonard was a brilliant lawyer with whom I worked a great deal. He won many important civil liberties cases in the 50s and 60s. But the organization could not sustain itself after Lamont died, and it's been absorbed by the Center for Constitutional Rights, another civil liberties group. So we're up to crisis 4, and that is the turbulent 1960s. Now, this era spawned many tough battles, both internal and external, when the ACLU was faced with new substantive issues well beyond its earlier positions. For the first time in the earlier mid-60s, it opposed capital punishment completely. Until then, it only opposed capital punishment if there was some defect in the procedures or that there was discrimination against a particular person on race or some other inappropriate ground. But for the first time in the 60s, it also sought to extend due process rights to juveniles. That was one of my cases. It declared an individual right to smoke marijuana and eventually hard drugs. It supported procedural rights for poor people receiving or trying to receive welfare, housing, and unemployment benefits. It supported the right to contraception and the woman's right to abortion. It joined but did not lead the revolution in criminal due process, exemplified by the Gideon case and the Miranda case. These and many other issues changed the ACLU culture, moving it well beyond the controversies that gave it birth. Indeed, some board members, some of whom I knew, resigned, saying they could not support the more comprehensive ACLU agenda, which they felt went beyond civil liberties to rights that did not belong within the purview of the ACLU. Now, at the same time, there were internal changes within the ACLU legal department that led to the ACLU becoming a more activist organization. For decades, the ACLU's legal department almost all the time filed briefs that I call the amicus, Friends of the Court brief, in which they gave their view about the First Amendment, the 14th Amendment, or whatever the issue was. But the litigators, the lawyers at the ACLU, which there were very few, I should say as a footnote, when I came to NYU in '61 to head the Civil Liberties Program, there were 2 lawyers, full-time lawyers at the ACLU in New York. Soon one of them left. Then there was only 1 lawyer. The second lawyer, 2 years later, was Eleanor Holmes Norton, who is the delegate from the Washington District of Columbia to Congress, a black woman who strongly supported our First Amendment position in a number of ways, because she herself had represented us, but I'm jumping ahead a little bit. In any event, after a very tough fight within the organization, footnote, the ACLU is really quite a democratic organization. There are votes like 40 versus 30, or 38 versus 31, and people really come from different parts of the country with different constituencies, and unlike many boards that are there just to raise money or to provide window dressing, the organization has some very good battles. In any event, the organization began to take on more and more the direct representation of clients. And what that meant was that the ACLU worked for and with the clients and guided the cases. Its lawyers planned and implemented the strategy. Before then, some other lawyer took the case and we just gave our opinion in a brief. Those are 2 very different things. Apart from everything else, to do the latter, you need a lot more money and you need a lot more lawyers. And all of this was taking place at about the same time. Now, I should say that I haven't mentioned Vietnam up to now, but that was one of the main issues in the mid and late 60s. And the ACLU eventually voted that the Vietnam War itself was a violation of civil liberties. And the reason it did so, even though there was much internal opposition, was one, Congress never declared war, and therefore it violated the Constitution. Footnote, none of our wars have been declared since World War II. And 2, the argument that the proponents made, I eventually voted for it, said that civil liberties violations are inevitably numerous and continuing during a war. You get people who are so-called draft dodgers, you have conscientious objection cases, you have military justice issues that are not resolved. In any event, the Vietnam War precipitated the change, this change I mentioned, and another important change in terms of how we represent clients, and something I haven't mentioned yet. In '68, the government of the United States indicted a group of anti-war activists. The leaders were Benjamin Spock, that many of you have heard of, the world-famous baby doctor, and William Coughlin, the chaplain of Yale University, and they indicted them for conspiracy to interfere with the war effort. Obviously a very complicated business, because what's a conspiracy is distinguished from a speech saying I'm against the war, but needless to say, these all have to be worked out. The staff, one of the defendants asked the ACLU to represent him, and the staff of the ACLU, the hired lawyers, of which there were not that many, wanted to take the case. It was a very big deal, to say the least, at that time, and many of you will remember that. And one of the arguments was that the Vietnam War was unconstitutional. But the ACLU had never taken that position. So how do you make this argument in court if, at this point, the organization had not stated this? So many in the organization argued that the right role for the ACLU was to file an amicus brief, taking a position on the civil liberties issues, free speech, freedom of association, others that Spock and Coffin and the other defendants took. And the board voted that way. But I haven't mentioned that by 1968, the board had become a little bit of a, I was almost going to say farce, for this reason, that throughout the whole history of the ACLU from 1920, the board was dominated. It was originally called the National Committee. It was dominated by New Yorkers and a few people from Boston, New Haven, and Washington. So it was a very closed circle. And the average social standing of the members of the board was somewhere between upper middle class and what I've called lower upper class. But that means there were some people who were upper class, as well as some people who were forced to endure being simply middle class. In any event, this board voted not to get into the Spock case, and it caused a revolution out in the rest of the country. And what the members in many, many states did was petition to have a meeting of what they called the full board, because by then there were other members of the board who didn't meet much, but they were technically members who came from the affiliates, one from every affiliate, Maine, Minnesota, Massachusetts, Indiana, every place where the ACLU had affiliate, which was then maybe 30 or so. Now there are affiliates in virtually every state. They came and they reversed the decision. And the decision was to go into the case and say that the Vietnam War was unconstitutional. Well, this, of course, was another example and was related to the fact that some of the old leaders of the organization couldn't take the new policy. This is in perfect good faith. They just had a different view of what a civil liberties issue was. So that was a part of the reason that the staff began to representing clients, and why we needed more money, and why things developed. Now I have a section here which I'm not going to go into, but it's called Who Runs the ACLU? And I've already given a hint, because the board used to be, before '64 actually, solely composed of the Boston to a Washington group, of whom 2/3 were New Yorkers. And they ran the organization, even though almost all the members were out in the States, the affiliates. And they had their own boards. But why should they take instruction from a board that is so unrepresentative? And that's when in '64 they expanded the board. But not until the Spock case in '68 did the issue have bite, when they overruled the New York board. Well, at that point, they changed the rules. I should say I was part of that, although not a leader, was that there would only be one board. The board would have some at-large members, 30, and one representative from each affiliate. And that was much more democratic. But the board grew to the point where today there are 83 members of the board. And you can see, while you have more democracy, it's very hard to have a conversation, and certainly a conversation in which X says something and someone wants to respond. And I chaired these meetings for 14 and a half years. You try to engage people, but it's very, very difficult. Well, the board has been wrestling with that issue, and they've recently slightly improved the situation. But anyway, Who runs the organization? In any organization, everyone here I'm sure has been in several, is the crucial thing. Who actually makes the final decision? And that changed. It changed from a New York-centered group of perfectly wonderful people to a group representing the country as a whole. And afterwards, after 68 and 9, the things that the board members would say were so different because they came from a different world. You know, the board member from Colorado just had different experiences from someone from Brooklyn. And it was a case where the organization developed. Well, meanwhile, as I said, we needed more money to support this operation. I haven't given all the reasons we needed more money, but that was basically a big part of it. But now we come to the first crisis, number 5 here, during my presidency. And that is soon after I was elected ACLU president in December '76, the ACLU faced a complex and vexing problem. A group of so-called American Nazis wanted to march in a suburb of Chicago to commemorate the birthday of Adolf Hitler. The group had no known relationship to the German Nazi Party and had no visible political or other power. Now, Skokie, one of the many suburbs they wrote to, said, Evanston and many others, we want to march on this birthday, we'll be peaceable. The Skokie leaders, Skokie was populated, a majority, I think, of the residents were Jewish. And many of them were concentration camp survivors or their children. So they were very understandably upset with the idea of having people calling them Nazis with swastikas marching down the street, even if peaceably. So they wrote formally rejecting them and passed laws like insurance requirements that would make the march more onerous. Well, anyway, deny the permit. The Nazis would deny the permit. They went to the Illinois Civil Liberties Union and asked them to represent them, because we're peaceable marchers. The ACLU represents peaceable demonstrations from the beginning. And the Illinois affiliate agreed. On the other hand, the story became a big story, and the New York Times ran a major article on it. And throughout the country, many people were very angry that the ACLU was doing this. Veterans, leftists, Jewish people, and it became an enormous problem for the ACLU. Now, I said in introducing this point that the issue was complex and vexing, but I didn't say difficult, at least for the ACLU. And that's because for decades, the ACLU has represented far-right, communist, racist groups who want to demonstrate peaceably. Unless there was violence, we represented any of these people in every situation. Now, thus, the ACLU had represented over the years demonstrations by Martin Luther King in white neighborhoods where they didn't love him, racists in African American neighborhoods, anti-war demonstrators, including Benjamin Spock, in or near military bases, and gay groups almost everywhere. All of these demonstrations seriously upset their audiences. So when the issue came to the National Board in 1977, after almost no debate, we voted unanimously to represent the Nazis. I mean, it was sort of an easy case in terms of the principle. Well, a large part of the public had a different view. Nazism was, to say the least, detested, and most people didn't adequately weigh the constitutional principle that permits any group, no matter how odious, to express their views peaceably. One consequence was that a large number of ACLU members resigned or refused to make further contributions to the organization. Now, at the same time, sort of unrelated to that, many members who had joined the ACLU in 1973 and 4, when the ACLU was the first major organization publicly to call for the impeachment of Richard Nixon. And we did big ads, and we raised a phenomenal amount of money and got a phenomenal number of new members. But these members learned over the 3 years from 73 to 76 or 77 that the ACLU was not a branch of the Democratic Party or a liberal action group. Instead was committed to defending the rights of everyone, no matter how unpopular or even despised as the Nazis were. So these members didn't renew. And then there were internal problems, which I don't have to get into, that also created financial problems. So we were in terrible financial shape in my first year as president. One staff member wrote that the ACLU was on a precipice. Well, fortunately, the ACLU received respect from those who may not have agreed with it on Skokie or other issues, but they admired the ACLU's willingness to put its money where its mouth was. And that comment was made, I might say, at a lunch that the Republican members of the Senate held for me in Washington about 6 or 9 months after Skokie. John Shattuck, who was the director of our legislative office, set up the lunch. I asked him whether any Republicans would show up. He said, "Don't worry about it. There was certainly going to be a big attendance and a vigorous exchange, but if it weren't for Skokie, none of them would have showed up because they would have felt we were hypocrites, that we spoke about freedom of speech, but we didn't defend it." Now, I should say, I had this somewhere, and I want to say it because of Mr. and Mrs. Adams. Well, I'll get to that in a moment. So a part I'm not going to state in detail. For a number of reasons, some of which are kind of interesting, the ACLU finances improved over the next year or so, a year or two, very substantially. And as I say, that's inside baseball, but needless to say, from my point of view and the point of view of the other officers, that was a very big thing. But ultimately, the ACLU was saved by principle, by being able to say to one and all that it stood by its values in the most stressful circumstances. Parenthetically, it is interesting to compare the explosive growth of the ACLU since Skokie with the fate of its British counterpart, the National Council on Civil Liberties. The NCCL at about the same time, and I knew the people in the organization, refused to take a free speech case defending the right-wing National Front. And in another case, it rejected a civil liberties claim that would have pitted it against a friendly labor union. The NCCL then developed a reputation for political partisanship. It lost strength and eventually had to reorganize, drop its name, and rename itself Liberty, which is now the name of the organization. I can't say I've stayed in touch with them lately, but they were destroyed by failing to stick with the principle. So anyway, that brings us, believe it or not, to 1980. And I'm conscious of the time here. This is crisis number 6. At just about the time Ronald Reagan was elected in November 1980, a number of very conservative religious groups emerged or became more powerful. Jerry Falwell's Moral Majority was probably the most famous, but there were a number of others. These groups had the primary interest of increasing the role and influence of religion in public life, thus eroding the separation of church and state. For example, they supported the efforts of religious groups to meet in public schools, would like to restore school prayer, wanted the public to vote in public elections in churches. These groups also opposed certain civil liberties that they believed and do believe were antithetical to Christian teaching, such as the extension of abortion rights to women and the efforts of the gay and lesbian community to end discrimination and lately to obtain marriage equality. Sometimes they interfered with a broad right of free expression and the attempts of prisoners and students to inhabit a religiously neutral environment. I think we're going to have to live with these groups for a long, long time. Some aspect of religious radicalism, I think, will be with us for a while. So now I'm finally at the 7th crisis Obviously, there's more that could be said about the gay rights and abortion and all the others, but I wanted to put this in some both context and short enough. The final crisis I'll discuss is global terrorism, which after 9/11 presented the ACLU with a problem much larger than the usual civil liberties issue. It's akin to the permanent problem, it seems, of racial and other invidious discrimination. The terrorism issue has many facets and a long history. For example, in the 1920s, as I've said, the aliens were viewed as a threat to American values and interests. And during World War II, tens of thousands of Japanese, maybe hundreds of thousands, citizens and non-citizens, were moved from their homes to what the Supreme Court of the United States called concentration camps. And during the Cold War, the communists were thought by many to be domestic revolutionaries who had to be put away in jail to assure civic peace and security. Now, 9/11 seemed to us, although I was no longer president, at a different level. The dramatic and destructive action on American soil, backed by the shadowy and powerful organizers, required the US government and other governments to decide how to respond and to develop a proper understanding of the many forces at work. All this led the Bush administration and much of the country to describe the situation compendiously as the war on terror, thereby triggering a deep national unity for a brief time, as well as a national sense of fear and uncertainty. President Obama has largely continued these policies. This should not be a surprise when we recall that Abraham Lincoln suspended the writ of habeas corpus during the Civil War. Woodrow Wilson, a Democrat, aggressively restricted speech during World War I, and FDR was responsible for the Japanese relocation in the early 1940s. Strong and perhaps unconstitutional action on behalf of national security during wartime is no respecter of party politics. But for the ACLU, the crisis was of another kind. How in these circumstances, when vengeance against the perpetrators of the greatest loss of life in a single attack, more than in Pearl Harbor, for example, can the civil liberties rights of those accused of the violence be protected, just as the civil liberties of an accused murderer must be safeguarded? To say the least, that was not an easy task, and it continues to this day, but it is an essential effort if the Bill of Rights is not to be watered down. Now, among the issues, the ACLU and other organizations, some of which got in ahead of the ACLU on some of these issues, including the Center for Constitutional Rights. One issue was attempting to dismantle the Guantanamo prison, in which 700 people were held at one point, without trials and in many cases lawyers. The current census is about 160. Illegal activities in Guantanamo and elsewhere, including possible torture and rendition of prisoners to other countries where torture might occur. The failure to provide trials or even charges against many imprisoned people. Extensive government spying on people through electronic and other means without a judicial warrant. We've just heard more about that, thanks or not thanks to Mr. Snowden. And government and private discrimination against immigrants who are or appear to be Muslims. Now, in this crisis, the whole seemed greater than the sum of the parts, and the ACLU responded accordingly. It brought or joined many cases, testified on legislative matters, and attempted to bring public opinion along. In a way, these issues are similar to the problems the ACLU faced at its inception, right after World War I. Now, despite all those efforts, not a single prisoner at Guantanamo has been released because of an ACLU case, and not a single judgment for money in a civil case has been judicially ordered by any court on behalf of the people whose civil liberties we argued were violated. But the good news is that our Freedom of Information Act case led to the release of over 100,000 pages of relevant material for the public and courts and journalists to review. Secondly, the U.S. courts, it was held to have jurisdiction to consider challenges to the detention of foreign nationals captured abroad in connection with hostilities and incarcerated. None's been released, but the courts at least have jurisdiction. Due process demands that a citizen held in the U.S. as an enemy combatant, and you've read about several, I'm sure, must be given an opportunity to contest the government's assertion that was an enemy of the United States, and that Congress's approval of military commissions that limit habeas corpus rights was declared unconstitutional. So we did set down certain markers that in the medium or long run may have results. But in any event, that was the seventh crisis. It's ongoing, and in a certain sense that's true of the others. In the interest of American civil liberties, this is my commercial. There's no doubt that the ACLU will have to maintain its strength and its principles in the years ahead. Thank you very much.
Thank you.
Dorsen has another appointment downtown in 45 minutes, but he's willing to do 20 minutes to half an hour of Q&A.
20 minutes.
Floor is open.
20 minutes.
20.
So I know the ACLU so well for its action in the judicial realm. Does the ACLU ever stake out positions in the legislative realm?
Yes, well, I sort of mentioned that in passing, and I understated that. The ACLU has a very, I am speaking the mic, but I guess, is it better now, Matt?
Yes.
I'm very sorry. The ACLU has a very large legislative office and works on legislation all the time. I should have mentioned, I did mention it, but it was buried. Every affiliate these days has a legislative person working for it. So the question you ask is an extremely important one, because a lot of things you can't get a court to do. So the only way you can make a change is for a state legislature or Congress. Now these days, it's very hard to get Congress to do a lot of things. But if you look back, we won many, many victories in Congress. The Civil Rights Act, the Voting Rights Act, and many other, not to mention things like the Environmental Protection Act or others that are not within our purview. So that's a very important point. And if I may, I'll just take another moment to say there's a third branch of the ACLU's activity, and that is public education. You know, we make speeches, we write letters, we have newsletters, we do a lot of work to try at campuses and other places to try to instill civil liberties values among the people. And to some extent, we've been successful because having 500,000 members, Roger Baldwin said at one time, in fact, he said it just before he died, it was 1990, he wrote that there are only a limited number of people in the country who will share our views. Now that, of course, was both pessimistic and elitist, because he was saying that we know what the hell's going on, but nobody else will. But the fact is, he would be amazed at the fact that there are about 500, give or take, because it fluctuates. And that's an extreme, let me say one line that I'm reminded, I used to say to the affiliates when I say I was speaking in Arkansas or in Indiana, I would always talk, of course, at some point about the need for money. You know, that's just part of the deal. But I used to say, I'm not even sure I believed it 100%, I used to say, it's more important to have members than to get them money. Why? Because members bring you into the community. Members mean that at a dinner party, if someone attacks the ACLU, someone is there saying, now 1 minute, the ACLU does some good things. And it sort of permeates the local culture. Now, who knows whether it's more important? You need the money to pay the lawyers and pay the legislative people, but having members, I don't know of any other organization that is like the ACLU in many ways, and one of them is the large membership, which brings us in. We're not foreign carpetbaggers in Alabama or Oklahoma. We're part of the community, and that's an extremely important thing for civil liberties. You asked too good a question. My apologies for going so long. Yes, sir.
Something that you alluded to that the ACLU, of course, has been involved with, but which I would like to suggest could almost be considered an eighth crisis, namely the war of drugs instituted in the mid-1980s, around 1986, I believe, in response to the death of a high college basketball player, in which we got mandatory minimums, we got the expansion of drug testing, and all sorts of other things which have permeated our society and only now are starting to be questions with the referendum on medical marijuana and the legalization in Colorado.
Well, that's also a very good question. We, as I said, took relatively early a position in favor of individuals' right to make decisions, and we've tried very hard. There are some people who are on the ACLU staff who regard this as the most important single issue because it meant the imprisonment of a lot of people for a long time just for smoking one marijuana cigarette. And we've done what we can, and as you also said quite correctly, until recently, we just weren't getting any results. But it's not just the medical marijuana. Many states don't enforce their marijuana laws against use. Many do, but it's a slowly upward curve, and it's a very difficult problem because people say, the ACLU position is, if you want to smoke marijuana, go ahead and smoke it. But supposing you smoke marijuana or driving a car, and you lose your stability, and you kill 4 people. So it's not, I'm not saying there's no argument on the other side, but that's true about drinking liquor as well. So these are all very difficult issues, and a lot depends on how you phrase the policy. We've spent many hours trying to develop the right wording to do as much as we can for civil liberties without sacrificing some other important value. It's not easy, but that's part of the deal. So that's also very, very important. There was someone in the back.
Number 6 was when Jerry Falwell and the Law Majority.
And the war against drugs, which was just pointed out to us.
But the religious groups that were trying to put religion into the public sphere, were there any court cases that the ACLU specifically worked on in the Jerry Falwell time?
Well, the answer is many, many cases, many of which we lost and a few of which we won. I have to confess, I didn't go back and reread the cases, although I'm slightly embarrassed. I used to know the cases somewhat better than I do now. But the fact is, we brought cases and we continue to bring them on every aspect of this issue. Now, here again, the problem gets a little more complicated because the Constitution, in its first words, the very first words of the Bill of Rights, are Congress shall make no law respecting the establishment of a religion. That's what we heard about from England. They have an established Anglican church. But the next phrase is, nor prohibit the free exercise thereof. So people who want to use religion say, I'm exercising my religion. Why can't I do it in the public schools? If the Boy Scouts can use this school, why can't the Methodist Church? We're citizens. They are also exercising their rights. So you have to draw some hard lines and you have to justify it. And one of the important things that I smile because I've said this over many years, you have to justify your position, not to the people like you who are more or less sympathetic with the ACLU. You have to justify your position to the people who start out against you, or at least neutral. I always like to say the open-minded, uncertain mind. The person who's willing to listen, but he's not on your side, or not necessarily, and you've got to persuade that person. It's not so easy to do that, because that person may go to church. That person says, well, why shouldn't the Methodists choir or whatever it is be in this public school if the Boy Scouts are? Well, write it down. If we had paper here, write down in two, three sentences what the answer to that is. It's not so easy, especially when you have to look at precedent. A lot of the precedent has not been favorable. But there's someone here named Engel, whose father was the plaintiff in the first school prayer case. I can't, where are you? I'm sorry. Yeah, there he is, Mr. Engel. His father brought the first case that declared organized school prayer unconstitutional in the Supreme Court. An enormous step. And other things happened that carried it forward. But in recent decades, it's sort of plateaued, and we've lost more cases as the court's gotten somewhat more conservative, certainly more conservative than the Warren Court, but also as the issues you raise get harder and harder, so that this open-minded, fair-minded person, even when he may start sympathetic, says, well, 1 minute, are we really being fair to our religious brethren? And I don't have a specific case I bring, but there are examples of after school should kids who belong to a religious club be able to meet in the school the way the chess club does, or the way the history club does. Well, you say to yourself, these are kids, they're 12 years old, they live in the neighborhood, why not? But you have to, now there are obviously people, and in this group it would represent them well, who would have strong feelings about that. But as you know, there are people who have strong feelings on the other side of these things, and you've got to persuade the unpersuaded, not unpersuadable, but unpersuaded person. And that's a large part of the job, and it depends on your ability to, in legislatures or in public fora or in the courts, to be persuasive, to think things through, to not seem too extreme, because you're not going to get a judge to go with you if he thinks you're sort of off the charts. And on the other hand, you want to represent your position strongly. So there's a lot to be thought about in this. Yep.
You mentioned the debate between the strategy of using amicus briefs versus direct legal action.
Yeah.
Can you comment on the effectiveness of amicus briefs? Do they weak? Are there examples where they're actually influenced?
Yeah, there are such examples. I know of them because justices have told me that. Nowadays, there are many, many, many more such briefs. When I was a law clerk, say, in the Supreme Court 55 years ago, we had very few amicus briefs. There were very few organizations. And those organizations like the ACLU may have had a couple of lawyers. So filing an amicus brief or getting some non-staff member to write the brief was a pretty big deal. You couldn't pay them, and people are busy, so you had to get people who were really committed to the ideology of the organization. But I know of cases where that has happened. Now, there's no way, at least I can think of, to quantify that, to say how many out of how many, or how different would it be if we had the client. Because, from the institutional point of view, it puts the organization in a more central place when you're representing Spock rather than somebody else and you're just writing a brief. But ACLU lawyers are not the only lawyers in the world. In fact, there are probably one or two good lawyers who don't belong to the ACLU. And who knows if we're doing the job right. There are times when there are things that happen that I used to feel maybe weren't so good. And people in the ACLU now internally might have a different view. And there were plenty of disagreements, as there is in every profession, about what's good work. Who is good at his or her job? Well, there are a lot of different opinions about that in every field. So, but there is some, to answer your question, there is some evidence.
Now, part of the problem that, as I see it, is where you're drawing the line. Okay, as far as I'm concerned, like in the example of marijuana, it's a relatively innocuous drug, innocuous drug. As far as I see it, it's less damaging than alcohol, as far as I see it, because I don't see, people going crazy and getting into fights, and they're high when they're high on marijuana. Right? So I could say, okay, fine, then marijuana is okay. But then you get to, where you're doing, well, what about methamphetamine?
Or cocaine or heroin.
And crack cocaine,
Well, let me answer that. First of all, the phrase you use to start, the problem is drawing the line. That is also the case, always the case. Can the police go into my house without a warrant? The question is, under what circumstances? Supposing they see an identified murderer come in with a young boy or girl, and should they wait for a warrant? It would be ridiculous. On the other hand, if there's no immediate emergency, they should call and get a warrant. Now, which circumstances, you can think of a lot of hard cases. Now, in drugs, in a way, it's easy because there's another, not easy, but there's another principle involved. See, when we voted to support as a civil liberties the right of someone to smoke a marijuana cigarette, what is the reason? The ACLU is not composed of physicians who can say exactly how healthful or unhealthful marijuana or liquor is. So we had to have a principle. You can't just say, we're for this. That's the key to the whole thing. Well, what's the principle? The principle is autonomy. The principle is people should be allowed to do what they want. That if they're grown-ups, what happens to children, it could be a different issue, not in every case, but in certain situations. So we say that grown-ups, because of their own authority over their lives and autonomy, can smoke marijuana. But that principle also applies to cocaine. And that principle applies to heroin. So how do you stop after marijuana? You can just say, well, heroin is more dangerous. Does the ACLU know that heroin is more dangerous? I mean, we can read the studies, but there's always a dispute among the doctors. And then the question is, even if it is somewhat dangerous, which I assume it is, by the way, is it outweighed by personal autonomy? In other words, even if it's dangerous, why can't a person of mature years say, look, I want to have heroin or cocaine, and I know it may be dangerous, but that's what I want. Why should you stop me? Why should the government stop me? So you get, you can see the kind, and this is true in every issue we deal with, John.
I'm going to exercise my privilege to ask you the last question.
All right.
You have over 60 years of experience with the Supreme Court. In your opinion, how do you think the Supreme Court is going to develop, is going to work, is going to change, is going to adjudicate over the next few years and the next 20 years?
Well, as I'm sure you know, that's an unanswerable question, but because it depends so much on the change in personnel. Now, that wasn't always the case. When I was a law clerk, the court was sort of divided the way the current court is, 5-4. There were 5, quote, conservatives and 4 liberals. The liberals actually, on the whole, were more liberal than the liberals on the court now. But the conservatives were also more liberal. The conservatives were Harlan, my boss, Frankfurter, Tom Clark, Charles Whitaker, and Harold Burton. There's no reason why you should know any of the names except maybe Frankfurters. And now, we thought they were conservatives, and during the 60s, when I was involved with the litigation before I became president and had to worry about other things, we thought of Harlan, my boss, and Frankfurter as conservatives, because they were the more conservative people in the Supreme, but they weren't conservatives. We now know what a conservative is, you see, and it's a wholly different thing. And that's true in Congress. Here's a fact you can win some money at if you bet. When the Civil Rights Act was passed in 1974, which was the main act, in 64, thank you, 64, involving employment discrimination, public accommodations, and other things, more Republicans in the Senate voted for it than Democrats. Why? Because you had the Southern Democrats who were conservative. Now, and the Republicans, many of them, not the majority, you had centrist people like Dorsen and a few others whose name, but there were liberals like Case, Mathias, Margaret Chase Smith, Hugh Scott, Jack Javits. There may have been a dozen really liberal people. They weren't liberal on economic issues. They varied. But on social issues, they were the best friends of the ACLU. But that's all changed. And I don't see a way for us to get back to that in the near future. So that's my very clear answer to your view. Thanks very much. You have my brief. I apologize. I have an old friend who's in New York. I haven't seen him.
There's still wine and cookies and stuff. Thank you very much.
Would you read?